Good morning, everyone. This is Rick Morgan. I'm a partner in the Columbia office of Burr Foreman. For those of you who are signing in thinking that you were signing in to watch the Alex Murdaugh trial, you're all on the wrong channel, but we have an exciting program for you despite the fact we're not going to talk about anything with criminal law today. We are going to talk about the ADA, FMLA, workers' compensation, what many of us refer to as the Bermuda Triangle. We appreciate you being with us today. If you have a question, let us know on the Q&A. We'll be watching the chat as well, and we'll try to address each and every one of your questions as we get through the program today. Chandler Aragona is with us here in our Charleston office, and she and I will be the presenters as we go through the program today. Next slide, please.
You want to go ahead and start, Rick, or do you want to wait a couple more minutes for people to log on?
Well, we've got 40 folks, it looks like, who are on, so let's go ahead and move forward.
Alrighty, we'll get started.
Yeah. Again, we're going to talk about the three things, the ADA, the FMLA, and the workers' comp, and how they interact and intersect with each other. You know, what we want to try to do with, go ahead, next slide, please. Is to understand that each of these statutes were written at different points in time and are focused on protecting different kinds of issues with employees in the intersection of employer-employee relationships. As we all know, the Americans with Disability Act protects individuals with disabilities from discrimination and that essential functions of the job with or without reasonable accommodations. Family medical leave also deals with health issues, balancing the competing obligations of workplace, illness, and family, and then the long-standing state-driven workers' compensation laws that we all deal with work-related accidents and injuries. Next slide, please. We know that there are certain events that really kick in whether a statute applies or not. We know under the Americans with Disability Act, we have to have a qualifying disability. We have that reasonable accommodation and that undue threat and direct threat and undue hardship that we deal with at the back end. But it's really kind of that qualifying disability, reasonable accommodation that we really have to focus in on. The family medical leave, as I think we all know, we're talking about serious health conditions, birth or adoption of a child, and that's in unpaid or paid leave substitutes. And then we have the workers' comp, the on-job injury or occupational disease, which takes care of the medical expenses, lost time or disability, possible disability benefits. I think it's important to note as we look at this slide, with the ADA in particular, you know, at the end of last year, we saw with some of the legislation that was passed, that we now have a reasonable accommodation built into our federal statutes with regard to pregnancy, and we need to be aware of that and planning for that in those states that do not have their own discrimination statute. For those employers here in South Carolina, we have had for a number of years reasonable accommodation protections built into our statute. So depending upon what state you are in now, we do have some federal overlay on what reasonable accommodations are required when we get into the issue of pregnancy and how that's going to all play in. While those Title VII issues are not a topic of discussion today, they do impact what we do when we look at accommodations in our family and medical leave requirements. Next slide, please. Part of the challenges that we all have when we deal with these three statutes is who really do they apply to? Well, we have employers with 15 or more employees on ADA. We have the family medical leave and the 50 or more within that 75-mile radius. And then, at least here in South Carolina, employers with 4 or more employees. And you would need to look for your specific state statute to see what your workers' compensation law covers. So you were going to really be looking at what law gives the employee the greatest protection and whether or not you are covered under that law as you try to understand and weave through these three statutes. Next slide, please. I think most of us know, who's a covered employee. For purposes of ADA, can that person perform essential functions of the job with or without reasonable accommodation? And we know that the disability definition goes to that impairment, whether it's physical or mental. It substantially limits major life activity as a record, regarded as such. And then when we look at the family medical leave, those conditions are listed on the slide, and I won't go through and read those off. What I'd like to do at this point, though, is to posit a fact pattern so that as we go through the next number of slides, we can talk about how you might want to address all of these competing interests. What I'd like for you to consider is this kind of a fact pattern. You have an employee who has what appears to be, with her primary care physician, some allergies, and from time to time, because of the flare-up of the allergies, will need to leave work. Employee provides to the employer through that primary care physician a family medical leave form saying that there will be times intermittently, not very often, that this employee will need to be off work because of those flare-ups of that allergic reaction that she has to certain things. And that she will need to leave work when she has that because the nebulizer just won't work and she'll need to leave the premises. Employer and she work under those intermittent requirements for a fairly long period of time, and then there begins to be an acceleration within that 1 year period of that intermittent family medical leave form, where it's not once every couple of weeks. It starts to be once a week, and then it starts to happen a lot on the Fridays and the like. And so the employer goes back and asks for some clarification from the primary care physician because of the acceleration of the number of occasions, which was not in the original report. The primary care physician says, well, that's really above my pay grade. I'm sorry, I want to send this patient to a specialist who can provide better information with regard to these allergies, and does so. Then the specialist who has been asked to provide clarification does send back some information, and in that she says that the individual needs a fragrance-free workplace, i.e. scents, chemicals, or molds at work. The employer takes a look at that and says, what scents, what odors, we understand mold. In the interim, from the reference to from the primary care physician to the specialist, the employer had done some very, very detailed and specific air quality testing to determine what might or might not be there. Sent to the specialist its fragrance policy and how it worked, and asked for some specific clarification as to what scents and what odors they needed to be able to address on the accommodation requirement. At that point, and from that point forward, neither the employee nor the specialist provide any further updates on what is a scent or a chemical that they would have to be aware of. Employer writes follow-up correspondence to the employee urging her to go to a specialist to secure that information, and gets nothing. Writes again and gets nothing. Writes again and gets nothing. And this time lapse goes over a period of time. With that background, then, I'll be asking you some questions as we go through the next slides. Go ahead, Chandler. Go ahead to the next one. We know the workers' comp, again, that's an injury rising out of course and scope of the employment. I note that some of those odors in that example that I just gave to you were at work, and that testing was performed. Again, I won't go through what that is. This is just a South Carolina code, what it has. I would urge you in your specific state to go through with your counsel or outside attorney who handles your workers' comp as to what and how those injuries are defined under your specific statute. Next slide, please. We know that there are considerations that we have to look at under each of our statutes. We certainly are looking at the reasonable accommodations, but when we get at the back end of it, if we have to look under an ADA analysis, whether there's undue hardship or direct threats, the kind of criteria that we would assess. I think the key is in any reasonable accommodation, those 4 bullet points are critical. You know, you need to be doing an individualized assessment. You know, accommodations are temporary. We need to have those interactive exchanges. Once you have those conversations, and you need to start them, I believe, early on in the process, because if you have someone who may be out, and in the instance of the hypothetical, you know, that person wasn't coming to work, was on intermittent leave, and we were trying to get more specific information driven by that initial FMLA request, the client was, so that it could meet its obligations for that reasonable accommodation under the ADA. You know, those periodic updates, particularly when circumstances had changed, was a proper thing for that employer to do. And of course, we can never have under any of our employment statutes retaliation against an individual. We know that the FMLA, under that period of time up to the 12 weeks, if they're out, have a right to reinstatement unless they meet that key employee definition. Okay, next slide, please.
And Rick, I'd like to add, when we discussed this a few weeks ago, you know, we mentioned that when you're communicating with employees while they're out on FMLA regarding periodic updates, those communications should probably be coming from human resources. I know that a lot of supervisors want to get ahead and plan their schedules, and they want to be the ones reaching out to the employees for scheduling purposes, but those communications really should be coming from HR. we don't want to create the appearance that we've got a supervisor pressuring an employee to come back to work.
Great point. Great point. Go ahead with the next slide, please. We know that these statutes, have overlap. If someone's out with a serious health condition, I think that flag ought to go up, and you say, well, we may be dealing with, an ADA issue, and that dialogue. And again, Chandler's point is very, very well taken. HR ought to be that group in your organizations that's having that conversation with them. There's no real guidance in the ADA when you look at all the case law and regulations as to what's reasonable or not, but that dialogue that you have, the size of your organization, the number of employees that may be performing that job, the criticality of that job, certainly are factors that you would be wanting to look at on your particular checklist as you have those discussions. One of the challenges that I've seen over the years is that when an employee finishes up their family medical leave, let's say they've been out for a block of time, I can't tell you the number of calls that I've had. Well, they're done with family medical leave, I want to go ahead and terminate now, which then goes to that intersection of family medical leave and ADA. The question is it a workers' comp situation? Has that person met maximum medical improvement? Those are terms of art, at least here in South Carolina, that we use under our comp law as to whether or not that person can come back to work in the job on which they were injured. So the mere fact that, for instance, a family medical leave block of time has been completed doesn't then let you get to some sort of, I can terminate now because family medical leave has expired. I think most employers these days, if someone does go out on a lost time injury under a workers' comp, is automatically giving a family medical leave notice. To the extent that you are not giving that notice, I would suggest that that ought to be something that you look at and become part of your normal protocols and internal practices. Always we're going to make sure that we're consistent with how we're treating individuals, so we don't get into some sort of other discrimination issues by treating people differently. All right, next slide, please.
Rick, it looks like you've got a question. You want to go ahead and
question in the chat? All right. Okay, let me see what the question is. All right. Let's see. Okay, I'm not seeing the question.
Okay, I'll go ahead and read it for you.
All right, here.
So if an employee does not qualify for FMLA, but there may be some type of accommodation that we could extend, for example, leave, flex schedule, remote work, etc., should or could we still ask them to complete the medical certification so that we can have more information? Of course, informing the employee that they do not qualify for FMLA, but the information is helpful in our assessment to their medical situation.
Great question, and the short answer, great question. The short answer is yes. The more information I believe that you have to make an informed decision with regard to an accommodation, the better off you are. My view in reading of all of the case law over the years has been, I call it best medical evidence available, to the extent that you can garner that kind of information to assist you in your decision-making process on an accommodation. I think that is a very prudent thing to do. And your approach of saying you're not eligible, but we need to get this information is a very, very wise and appropriate approach, and certainly would encourage you to continue to do that. All right, great question. Next slide. All right, FMLA, that's the essence of, leave is the essence of FMLA. If the person's eligible, don't deny it. Many employers, and I think properly so, err on the cautionary side and will at least provisionally grant FMLA leave while they're going through that dialogue process for that portion of the claim, and that you ought to be looking at that. Under the ADA, leave is not always the answer, but may be a reasonable accommodation that you can consider. Okay, next slide, please. And then we have our workers' comp that plugs in there. Again, you've got to look at what you're dealing with. Is it a temporary issue, a temporary impairment under the workers' comp that can be sorted out over a short period of time? Is it really going to be a substantial impairment of a major life activity such that you have to get into reasonable accommodations? That analysis, when it gets to a comp situation, should be assessed. And if the person's out for a period of time, they'd have the comp, they'd have the FMLA under what my view is, and then you would continue the analysis to see whether or not there is that substantial impairment for purposes of ADA consideration. All right, next slide, please. The work-related injury, I think if you're on a lost time accident or injury and, you meet the treatment by the doctor, the 3 or more days, all of those definitional issues that you get into under FMLA, if I just get a scratch or a cut, I may have a work-related accident, may not be FMLA, but make sure that if someone is out for a period of time that falls within the definitional criteria of FMLA, that you give them that FMLA notice. The question that we see asked from time to time, if I'm out on workers' comp, can I use something to supplement so that they get full pay? That's a business decision that the employer can make, and that's within the culture of your organization on how you wish to address that kind of issue internally. All right, next slide, please. All right, I think we're up to the benefit portion. I guess my question is, before I turn it over to Chandler, is with the hypothetical that I laid out at the beginning, where after 90 days there was no response at all, either from the employee or the specialist, with regard to what is a scent or odor, what would you do? And we'll come back to that question at the question and answer and talk through how you might wish to address those kinds of situations. Chandler, I'm going to turn it over to you.
Rick, you muted yourself, but we do have a question before I move on to benefits, and I can go ahead and read it aloud if you'd like.
Okay.
All right. So
I see it. I have it. Go ahead. Okay. Go ahead and read it.
I have an employee who is requesting ADA FMLA accommodation due to not being able to report back on site 3 days a week. We started bringing employees back at the middle of last year. They are still currently 100% remote and have provided medical documentation regarding their health condition. Their job requires them to be on site 3 days a week. Is there any way we could accommodate this employee?
If you have essential functions of the job that now require someone to actually be at work, I think the first part would be, what does that job description say? If the job description says, for instance, if I have to turn a wrench, by way of example, the only way I can turn the wrench is to be on site, then I got to be on site. If they've been 100% remote, what now drives the requirement to be on site 3 days a week? Is it specified and set forth in the job description? Do you have a means to articulate properly to them and on down the road, either to the EEOC or to a court or a judge or a jury, why they now have to be on site to do their job? If they can't be on site 3 days, can they be on site 1.5 days or 2 days? I would probably need a little bit more information on that, but there are some building blocks that you would have to go through to fully analyze whether or not that's a reasonable request or not, based upon a lot of different criteria. It sounds a little bit suspect to me, but I think I would need more information before I gave a full opinion.
Okay, thanks, Rick. If we get more information in the chat, I will go ahead and read that to you.
All right, I'm going to go ahead and mute Chandler.
Absolutely. And Rick, if I miss anything, feel free to jump in if you have any comments. So I'm going to start talking about benefits with respect to these 3 issues. And we'll first start with FMLA. And the law says an employer has to maintain an employee's health insurance benefits while that employee is on FMLA leave. So whatever kind of coverage the employee had during their employment, whether it's singular coverage or family coverage, that same coverage has to be maintained while the employee is out on leave. With that being said, the employee is still required to make their premium contributions just as if they were not out on FMLA. So regardless of whether or not the employee is on paid or unpaid FMLA, they still have to figure out how those contributions are going to be made. So obviously, if they're out on paid leave, those contributions are going to come through their paychecks. If they're out on unpaid leave, they're going to need to make arrangements to get those contributions to you. We can't cancel the employee's health insurance coverage unless 30 days goes by and you do not receive a payment for those insurance premiums. If 30 days goes by, then you have the right to inform the employee in writing that their coverage is going to be canceled if you don't receive payment. And after that point, if an additional 15 days goes by and you still haven't received payment for those insurance premiums, then you're permitted to go ahead and cancel that coverage. But when the employee returns from FMLA leave, we've got to restore that coverage just as they were receiving prior to going out on FMLA. And recouping those benefits or recouping those premium payments that they didn't make is going to be a separate issue that we'll have to deal with. So your specific policy is going to determine whether or not an employee accrues vacation or sick leave while they're out on FMLA. So it's important to note that however we're treating employees who are out on other types of paid or unpaid leave is the exact same way that we have to treat employees who are out on FMLA. There's an FMLA regulation that says an employer must treat the employee using paid leave while on FMLA leave the same way it treats employees on other types of paid leave, such as regular or sick leave. So if you've got an employee who's taking vacation, Is that employee also accruing PTO while they're out on vacation? We've got to then treat the employee who's out on paid FMLA in the exact same way. Whether or not an employee receives pay while they're out on FMLA is going to depend on your specific policy. Obviously, the law says that employees are entitled to 12 weeks of unpaid leave. Some employers provide 4 to 6 weeks of paid leave. Some don't provide any at all. So that's just going to depend on your specific policy. And regardless of whether or not the employee is receiving pay during their leave, an employer can require that employee to exhaust their PTO concurrently with their leave. Rick, it looks like we have another question that is pertaining to ADA accommodations. I can go ahead and read it aloud. It says, I have several pending ADA accommodations. I'm having issues receiving documentation back from them. What accommodations are they requesting and medical information backup. Currently have no written ADA policy, which will be remedied. In the meantime, we are actually accommodating them to the best of our ability. What can we do to get the information back? By accommodating them in the meantime, are these cases actually already being completed? You're still on
I think
mute.
the answer to that question is this. One, what are the accommodations? Are you engaged in a dialogue with that employee to try to get that information from them so that you can make a decision? The fact that you don't have a specific written ADA policy is, I don't think, determinative of what you are doing, but you need to continue to have the dialogue within, sound business approaches. That accommodation makes sense. I don't see in the question that you're to an undue hardship yet. What I've done in situations like that is you give people deadlines on the information that you are requesting. I mean, you can't say, I need it by tomorrow, understanding that a lot of docs these days, don't immediately get back to them. And I've seen in the literature that we now have doctors charging for this kind of information and questions from patients where they're taking time away from actual patient treatment. But give them a deadline. I try to then maybe give them a next deadline. And if there's a failure to cooperate at some point, and I will tell you that in the hypothetical that I gave to you at the some of my opening comments, that employer after 90 days made the decision. The employee was out on leave, wouldn't come back to work because she wouldn't come back to work unless the employer agreed to allow her to continue to take time off whenever she desired to take time off. After a 90-day period of time, the employee had exhausted all leave benefits. That employer had extended leave. There was no more pay. She was in an unpaid leave for a period of some 45 days, and her absolute failure to cooperate with the employer led them, after working with her and in dialogue, documented in writing in 5 or 6 pieces of correspondence, and informing her that her failure to cooperate, was placing her job in jeopardy, made a decision to terminate the employee. And there is case law out there that supports that when you've done everything and an employee just is going to blow you off completely, allows you to make those kinds of decisions. That's been some 120 days ago, and we've not seen an EEOC charge or any piece of litigation yet from our employer on that decision to terminate. So something may come of it, but you have to try to be able to manage. Hope that answers your question.
Rick, let me ask you this. I think it might create some good questions. At what point, if any, should we be communicating with the employee's physician, and does that create any HIPAA issues? You're muted.
Yeah, yeah. Yeah, send them to the employee to take them to the doctor. And if you have HIPAA releases and whatnot that you have been given permission to deal with the doctor directly, you can do that. For instance, in South Carolina, under our workers' comp law, you can deal with the doc directly by statute. So look at your state statutes. If you have a mini FMLA law that allows dialogue with the doc, do that. I prefer to have a HIPAA release when I deal with the doctor directly. That protects everybody in the situation. I'm sorry, Chandler. Now you had a question.
Oh no, that was almost exactly my question. I said, at what point, if any, should we be communicating with the physician directly, and what kind of HIPAA issues does that create? But I think that was a pretty spot-on response.
Okay.
I think we have answered the question that was posed. We'll go ahead and move forward in the slides. Now we'll talk about benefits while you've got an employee who is on an ADA leave. And in this regard, there is no requirement by the employer to maintain health insurance benefits while the employee is out on this type of leave. But we do want to be careful to treat an employee who's out on an ADA leave in the same way that we're treating an employee who's out on some other type of leave. So say, for example, we've got an employee who's, say their spouse died and they're out on some type of bereavement leave. However, we're treating that employee is the exact same way we want to treat the employee who's out on ADA leave. Don't want to inadvertently discriminate against this individual who's out on leave based upon their disability. The workers' compensation benefits. If you've got an employee who was injured on the job, there's 3 different types of benefits that employee can receive. And the first are these temporary disability benefits, and that is the 2/3 of their average weekly wage. So if the employee is out of work due to the work-related injury, they're going to be receiving that 2/3 of their weekly wage. They're also going to receive payment of their medical expenses. And the last category is permanent disability benefits. And that's the scenario if you've got an employee who's had, extensive medical treatment, physical therapy, etc. At the end of that treatment, if you've got a physician saying that this employee is still permanently and totally disabled, and they've got a certain impairment rating, then they're going to be entitled to receive a certain percentage of these permanent disability payments. Oh, we had a question, but we did. So obviously, if you've got a work-related injury, an absence from work may be necessary due to that injury. And you can offer light duty to keep that employee at work. If you would offer that employee light duty, they have no choice but to accept it. If they refuse to accept the light duty work, then they forfeit their benefits under workers' compensation. While the employee is out on workers' comp, the requirement to maintain their health insurance benefits is going to depend on your specific policy. So break out your handbook and figure out what your specific policy is in that regard. And regardless of what your policy says, if that employee, if they want to maintain their health insurance benefits, they're still going to be required, just as with respect to FMLA, to make those insurance premium payments. And I believe that the payment schedules are different. If you've got an employee who's out of work and they're receiving that 2/3 of their weekly wage, I don't think that their insurance premiums are going to be automatically coming out of that wage. So they'll want to make arrangements with you to get those premiums to you as well. So we'll get into light duty, these 3 regards now. And I think we all know light duty is work that is less physically or mentally demanding than normal job duties. So start out under ADA and FMLA. With respect to FMLA, an employer may offer light duty work to an employee who is eligible to take FMLA leave. That employee is not required to go on light duty instead of going out on their FMLA leave. And one thing to be cautious of in this regard is if you offer an employee light duty and that employee is entitled to go out on FMLA, that employee could work in the light duty position for several weeks. And then they decide that they want to go out on FMLA to have surgery, whatever the reason. And that time spent working in the light duty position cannot be counted towards any FMLA time. So you want to be careful of that issue. You know, you don't want the employee to be in a light duty position for weeks on end, and then they decide they want to take the 12 weeks of FMLA. On the other hand, the reduced hours, that can be counted towards FMLA time, just to make a distinction. So with respect to the ADA, employer is not required to provide light duty as an accommodation. The ADA doesn't require employers to create permanent light duty positions for disabled employees. If the light duty position proposed removes the essential functions of the employee's job and basically creates a new position, you're not required to do that under the ADA. But if the non-essential functions of that employee's job can be removed, which allows them to perform the essential functions of their job, and that could be a light duty position that you could be required to offer under the ADA. If you choose to offer light duty pursuant to the ADA, you only have to do that on a temporary basis. You're not required to do that permanently and create an entirely new job position. So with respect to workers' comp, a lot of employers like to offer light duty to the workers' comp employees, so that way the employee can stay in work and they don't have to report the injury as a lost time injury. And one thing that you want to be careful of is strictly offering light duty with respect to workers' comp injuries, because one could make the argument that you are inadvertently discriminating against an individual with a disability under the ADA. You want to treat the employees who have work-related injuries just the same as you're treating those who are alleged to be disabled. I think we touched on this earlier. If an employer offers light duty work to an employee who is out on workers' comp leave, that employee has to accept the light duty work, and if not, they forfeit their benefits. Rick, anything you want to add on the light duty workers' comp?
No, I think that's good. Yeah, we're good.
All right. So now we're going to go into an example that we think touches on all three of these issues. So Alice Morgan, an assembly line worker, has called in sick for 3 days, citing extreme back pain. She's been with her employer, a company with over 100 employees, for 3 years and has been working full-time with very few absences. So this entity is covered by FMLA, and this employee sounds like she's been working there long enough to be a covered employee. Alice called in sick on the 4th day, stating that she was examined by her doctor, who took x-rays and stated that she needs complete bed rest and possibly back surgery and will be unable to work for an extended period of time. She has not provided an anticipated return to work date. So on this second bullet point, I think that we're probably looking at putting this employee on an FMLA leave. I don't think that based on the facts here, we would want to put this employee on it. We don't want to accommodate this employee with respect to the ADA. It sounds like she needs back surgery and she cannot perform the essential functions of her job at this time. Alice states that her doctor thinks the condition is caused by the type of work she's been doing, that she likely has a workplace injury. This is a perfect example of how you end up in the middle of these three issues. You're going to want to provide this employee with the most protection that they can be afforded with respect to these three laws. So using these areas of the interplay between these ADA, FMLA, and workers' comp. Obviously, we know this is a covered employer, and the employee is eligible for FMLA. And now that we know that her physician thinks that this could be a workers' comp claim, we should still also file a claim, even if the employee goes out on FMLA. We should still also file a workers' comp claim, and it should be processed with the carrier to make a determination as to whether or not it's a covered claim. With respect to the leave of absence, leave as a reasonable accommodation under the ADA is not an issue at this point because her absence with proper medical certification will likely be designated as FMLA. The employer should send the forms to Alice for timely completion and return to be completed by her physician. Should her absence exceed 12 weeks, additional leave of absence may be a reasonable accommodation. So if Alice has back surgery, is out on FMLA for 12 weeks, and at the end of that 12 weeks, she can still not perform the essential functions of her job, the leave of absence can be an accommodation under the ADA. You know, this employer is not required to provide this employee with an undetermined amount of leave. You can kind of take it as you go. You know, maybe will an extra 2 or 3 weeks allow you to recover and come back to perform the essential functions of their job? Those are going to be the questions that you're going to want to ask this employee at the end of their 12 weeks of FMLA. You're not required to grant an indefinite leave in this regard. The employer can request periodic updates about her condition and anticipated return to work date. Again, I think those communications should be coming from HR rather than the supervisor. You don't want to create any type of supervisory pressure. If the condition is determined to be work-related, workers' compensation leave will run concurrently with the FMLA. Under the ADA, no medical documentation is required yet. ABC Manufacturing should require FMLA certification to support the leave request. Workers' compensation insurer will require medical documentation. So at this point, take a look at the employer should take a look at their FMLA policy. Is paid leave permitted in this situation? If not, then they're entitled to the 2/3 weekly wage pursuant to workers' comp. Restricted or light duty. I don't necessarily think that we need to worry about that in this situation. It seems like at this time, the employee is not able to perform any functions of her job. She needs back surgery. Obviously, if she has the surgery, exhausts that 12 weeks, at that point, I think it needs to be determined what, if any, functions of her job she can perform. When she's able to return to work, she has medical restrictions, the employer must offer light duty if available as a reasonable accommodation under the ADA, unless this creates an undue hardship. The employer may not require light duty if FMLA leave is still available. So if this employee she receives back surgery, and say she's 8 weeks into her FMLA, if she could perform light duty work but still wants to take the remaining 4 weeks of her FMLA leave, she is well within her rights to take that remaining leave. You cannot require her to come back before that leave is exhausted. Light duty can be required if she's strictly out on workers' compensation leave. A fitness to return to work, we're not necessarily looking at that issue at this time because she's unable to work in any capacity until further notice due to her back issues. It looks like we've got a question in the chat. Is there anything different in the ADA accommodation analysis if the employee's disability was caused by an elective surgical procedure? Rick, I don't believe that changes the analysis. Do you have
elective procedures are not ADA covered when you look at all the regulatory guidance. And for family medical leave, elective procedures are not covered as well. Now, if that elective procedure did have some impact that a doctor somehow said it was a serious health condition or some sort of disabling issue, making it a qualified disability, you may get there, but just generally, I don't think so, no.
We've got an additional question. What if an employee sustains a workplace injury and was granted FMLA and has subsequently been given more leave and is being paid via workers' comp, but remains to be out of work with no clear expectation as to a return to work date? It's been about 4 months. Due to the employee's injury and position, no light duty is available. How long do we have to keep the employee? When can we end the employment of the injured worker?
What you're looking at there, what I'll say, you've blown through your FMLA, so I think that's going to be done when you're talking about, 4 months. Once you get past that 12 weeks of complete time away, I think we can say FMLA, at least on the leave portion, is off of the table. Now you're into the return to work under the comp component with an ADA analysis. And since, at least in South Carolina here, you can have that direct correspondence with the doc, I think you need to be very, very proactive, deal with the doc if your state statutes allow you to do that. Try to push to find out whether you are getting to what we call, at least in South Carolina, MMI, maximum medical improvement. Get to some sort of disability rating. At least here in South Carolina, for purposes of workers' comp, RALJs and commissioners are looking on that MMI requirement. But that's where you have to be proactive and interactive with the doc to get them to make that decision. If you just kind of take a laissez-faire attitude, that thing can go on and on forever. And at least here in South Carolina, you're going to be toast as far as how long you have to keep that person on leave. But once you get to that MMI, you're then going to, I think, get to, can they perform the job that they were in, or is there some other job that you can move them to under an ADA analysis? And you would get into all of those parts of the equation. Going back to
Rick,
that one question that we had early on, about interaction with the doctor, that's why I think it's so important. I'm sorry, Chandler, I talked over you.
Oh, no, that's all right. I just didn't, I was curious what your thoughts were on retaliation issues in that regard.
I'm not sure that I don't see retaliation here, but you can't use the fact that someone's been hurt at work. You can't use the fact that they're using a leave to take an action against them because of that factor. Okay. Here's some questions. To clarify, the job description requires the individual to be on site. The employee was placed in that role, but it's the remote due to COVID. We started bringing a hybrid setup last year. Has been able to fully perform. The current role can be done remote, most of this. Okay, the follow-up question on the job description. Employee has been able to fully perform. The current role can be done remote. Most of their responsibilities are virtual and 25% travel requirements. That one I think is a really tough one. I don't know how you get them in 3 days if you can work remotely. I'd have to give that one some real thought and chew on it. I don't think in the short time we have today that I can give you a definitive answer on that. I'd have to do a lot of analysis. We're trying to see if an accommodation can be done. Okay. And then we have one here. We have employees that work 7 days on, 7 days off. Would they be entitled to 12 weeks of FMLA or 24 weeks. Statute says you're entitled up to 12 weeks of leave unless you get into some sort of veteran issue, which has a broader period of time. Where you can run into problem depending upon when you start your FMLA leave. I've had employers do it on the calendar basis. Someone's out at 12 weeks at the end of last year, and then they start new because they met the 1250 hours in the prior 12-month period, and they can take an additional 12 weeks beginning in January and be out for 24 weeks. But the statute itself is limited to the 12 weeks FMLA unless that veteran issue kicks in. All right. I think we've got about 5 minutes left. Chandler, why don't we jump back to you? I think I've tried to answer all of the questions that I see posted.
I think this is my last hit, unless we have any additional questions come in. And it's just briefly benefits while that employee that we discussed earlier was out on leave. Obviously, we're not required to maintain her health insurance benefits if she's out on an ADA leave under FMLA. We are required to maintain those health insurance benefits. She's going to be responsible for those insurance premiums. No additional benefit continuation if she's out on workers' comp. When she returns to work, we have to restore those benefits just as she had them before going out on leave. Reinstatement, she would be entitled to her previous job unless doing so would create an undue hardship on ABC Manufacturing. Again, if she can perform the essential functions of the job and return to work before she exhausts the 12 weeks of FMLA or at the end of the 12 weeks of FMLA, we have to reinstate her to the same or similar position with equal pay and benefits. Workers' comp does not provide for reinstatement under most state laws, but we can't retaliate against her for becoming injured in the workplace. And that's all I've got on my end. I don't know if we want to stick around for a couple more minutes or.
Well, it says that there's some open questions, but I think I've answered all the questions that are up there, unless I've missed it.
I don't see any additional.
All right. And I'm told I've answered all the questions. Well, no more questions, folks. We really appreciate you being with us today. We appreciate your support of our Burr morning programs. We enjoy doing that, being with you, even if it's in a webinar setting. We look very carefully at these programs. We listen intently to what those who have signed in want to hear about. We try to put on programs that are of interest to not only our clients, but others who want to dial in and hopefully learn a little bit more about the topic that we're presenting. We thank you all for being with us today. If you have any questions of either Chandler or me, our information is up on the screen right now. And please feel free to contact us and let us know that you are a participant in the program, and we'll get back to you. What about the employee with the allergies in your example? What the employer did after 90 days, having had her expire everything, they made the decision to terminate her employment for failure to cooperate and engage in the dialogue interactive process for that 90-day period because she went radio silent, so there was a termination. And I don't know, Michelle, whether we give these presentations out or not. I'll leave that up to Michelle and Grace. I don't think we send these out. But if we do, we'll get those copies to you. All right. Anything else? Thank you very much. We appreciate everyone being with us today. Everyone have a great day. You can maybe dial in on the Alex Murdaugh trial now.
Thanks everyone.
Everybody.